Very good morning to all younger advocates appearing for judicial examinations. The last video number 1, I have done a video on law of easements in part. When we are doing that video about natural rights, there was some interruption in the supply and that was discontinued, and in continuation of video number 1, as far as easements rights are concerned, I am doing the second video. In the first video, I have spoken about profita pendere, that is a benefit arrived from the land, and fish in the tank is a profita pendere and it is an immovable property. And that I have not given any authority on that, and today I am giving that is AIR 1977 Supreme Court, page 2149. ఇది బీహార్ ఈస్టర్న్ గంగి ఎంసీ ఫిషర్మెన్ కోఆపరేటివ్ సొసైటీ లిమిటెడ్ వర్సెస్ సిపాహీ సింగ్ అండ్ అదర్స్. So, in this judgment, AIR 1977 Supreme Court, page 2149, in this judgment, that proposition which have said that the fish in the tank is a profita pendere and it is an immovable property, that proposition is held in this decision. So, you are basing on this decision, you are supposed to follow the latest case law also. So, this is the decision on that. In this decision, it is clearly that proposition is laid down. Then on the other day, I was speaking about the natural rights. So, what natural rights are concerned are those incidents and advantages which are provided by nature for the use and enjoyment of a man's property. These rights are treated by law as the ordinary incidents of property and annexed to the land wherever land exists. Thus, every owner has the right to build on his land in any way he likes, to enjoy the air and light passing over his land, but also has a right not to have his physical comfort interfered with materially and unreasonably by noise or vibration caused by any other person. He also has right to the water which passes by or over or percolates in his land. These are all natural rights, right to air, right to water, and incidentally attached to the, naturally attached to his land. So, all these rights are natural rights. Now, it will be some more clear, because what is the difference between easements and natural rights? So, easements and natural rights mean natural rights are annexed to the land naturally, no interference of human being is required. Here, whatever the easements are concerned, that easement somebody has to have to grant that right, or by prescription one gets that right. So, the conduct and acts of human beings are required as far as easement rights are concerned. Just I will read out. Easements are acquired rights abstracted from the ownership of one man and added to the ownership of another, whereas natural rights are themselves part of the complete rights of ownership belonging to the ordinary incidents of property and are ipso facto enforceable in law. That are difference between easementary right and natural rights. Natural rights are secured to the owner of the land by the common law of the land. They are inherent in the land, most important. They need no age to ripen, nor any particular incident to create them. Easements, on the other hand, are not automatically available to every owner of the land, but are created by special human acts or incidents. They are artificial or conventional and must be acquired by grant, prescription or other means. So, with the background I have done in video number 1, you can easily understand difference between a easementary right and a natural right. Okay. Then next chapter is chapter 3 is section 8 to 19. There you can deal section 8 to 11, who can impose easements. who can acquire easements, easements of necessity and quasi easements. This is also an important chapter. And acquisition of easements by prescription, prescriptive rights, that is sections 15 to 17. Then customary easement and effect of transfer of dominant heritage. So, by now, by seeing the video number 1, what is dominant heritage, what is servant heritage? Heritage is nothing but land, tenement is nothing but land. So, owner thereof is known as dominant owner and servant owner, that I have already explained in the first video. Now, section 8 to 9 is concerned, who can impose easements. As far as imposition of easements is concerned, as easement may be imposed by anyone in the circumstances and the extent in and to which he may transfer his interest in the heritage on which the liability is to be imposed. So, it is an important question, who may impose easements. Then who may impose, I am also, why I am reading the illustrations, and because the multiple choice, what they ask is, from out of section they pick up something and ask in multiple. Until unless you are acquainted with that, and if you go through that, then only you can remember that this answer is so and so. That is why I am also reading sometimes relevant portion and also giving reading illustrations. So, rest of the illustrations, for better understanding, you need to read illustrations. Here, a servant owner may impose on the servant heritage any easement that does not lessen the utility of existing easement. So, already we have discussed, it is very easy to understand. Already what is a servant tenement and servant owner is that where a passage is there in that land for the beneficial enjoyment of others' land, that is dominant land and dominant owner, dominant tenement and dominant owner's land, a passage right is there in the servant owner's land. Now, the servant owner can impose and can grant somebody also some rights across his land, but is granting such rights should not disturb already existing passage right of the dominant owner, that is most important. So, that is who can impose easements, he can impose, but already existing right of the dominant owner for beneficial enjoyment of his land should not be disturbed, that is most important. Then a lesser, section 9, that was it, now 10, a lesser can impose an easement that does not derogate from the right of the lessee. So, lesser, who is the owner of the land, also can impose easement, but already has given that land to on lease, but that lessee's rights should not be disturbed. As long as lessee's rights are not disturbed, he can grant easement to somebody else. Then a mortgager can impose an easement that would not render the security insufficient. So, a mortgager also can grant, but provided the security should not be spoiled. Then, but a lessor or mortgager cannot impose any other easements without the consent of lessee or mortgagee, unless it is to take effect after expiry of the lease or redemption of the mortgage. So, here whether the lessor or mortgager, they can't impose or create any easement or any other easement without the consent of lessee and mortgagee. That is more important, because lessee's term will be there, mortgage also redemption period will be there till that time. So, they have to consult lessee and mortgagee. Then this section 10. The next one, a lessee cannot impose on the property leased to him any easement that would take effect after the expiry of his own interest and in derogation of the right of the lessor. సో లెస్సీ ఆయన టర్మ్ అయిపోయినా కూడా ఒక రైట్ ఎగ్జిస్ట్ అవుతుంది, సంబడి ఎల్స్ కెన్ యూజ్ అనే ఈజ్మెంట్ ఎవరికి ఇవ్వకూడదు, ఆయన టర్మ్ అయిపోయినా కూడా ఎఫెక్ట్ అయ్యే రైట్స్ ఎవరికి ఇవ్వకూడదు. అలాగే ఇన్ డెరిగేషన్ ఆఫ్ ది రైట్ ఆఫ్ ది లెస్సర్, ఆయన హక్కులకి భంగం కలిగించేటట్టు కూడా ఇవ్వకూడదు అనమాట, అది సెక్షన్ 11. దెన్ నెక్స్ట్ వచ్చి who can acquire easements, who can acquire. So, who can acquire? An easement under the act may be acquired in any of the following 9 ways, that is by grant under section 8 somebody has to impose easements. Then by necessity when there is a severance of two tenements. So, by necessity, easement of necessity, that I will explain this when we come to that subject. Next, by quasi necessity, that is also when there is a severance of two tenements. And severance of two tenements is nothing, severance of tenement is land, severance of land. So, severance of land, when it is will be said it is severance of land, suppose one gentleman is having 2 acres of land. So, out of 2 acres east west let us say, and he sold western side 1 acre to somebody else. So, it is a severance by by selling, or two brothers are there having 2 acres jointly, they effect partition, they get each 1 acre. So, when they effect partition it is severance by partition, or a father gives a gift to the daughter out of 2 acres 1 acre. So, that is severance by gift. So, severance means when it was a common plat at one point of time it is severed and it is given to somebody else out of that total extent of 2 acres. That is how in the Easements Act the word severance is used in that respect, in that reference. Now, quasi easements, there is a severance, these quasi easements and easements of necessity arise when there is a severance of common tenement and a severance of common land by sale, by partition, by whatever means. Okay? Then next, then by prescription. So, by prescription means you have to continuously, uninterruptedly, peacefully, without violence, you should enjoy certain right under Easements Act for 20 years, not less than 20 years. That I will explain in detail. By last grant presumed immemorial user. What is last grant? This is also an important. What is last grant is one gentleman is using some particular right since more than 20 years or 30 years. So, that comes in, that was in dispute now. Now, what is under by last grant, presumption of last grant is that by his long enjoyment, law presumes that he was lawfully granted that right from somebody, but he lost that. Suppose some paper, example, one paper somebody has executed giving some easementary right to me. I have been enjoying for last 20 years. So, long use is there. So, a paper now there is no paper with me, that is destroyed or gone anywhere, lost. So, law presumes by your long use of that right that some legally some right was granted to you, that but it is lost. So, that is what last grant. Then by custom, section 18, customary rights, that I will tell. By transfer of dominant heritage, section 19. So, I already said dominant heritage means dominant land for whose benefit some passage right or some right exists on somebody's land. So, when dominant heritage is transferred, so consequently with all easementary rights only it will be transferred until contrary appears in the document. Then next, by legislation, but as for instance the rights granted to owners, lessees and occupiers of mines under the Land Acquisition Act. So, these are all suppose lease, then occupiers of mines. So, some rights are granted by statute. So, those rights. So, there are 8 types of rights under head how easements can be acquired. So, here now the next by operation of doctrine of acquiescence. So, what is doctrine of acquiescence? That also I will explain. But here now coming to who can acquire easements. So, how easements are acquired or created? These are all sections 8, 13, 15, 18 and 19 already said just now by grant and all. Next easement of necessity and quasi easements. Easement of necessity and quasi easements. So, what is easement of necessity? Easement of necessity is that when a common tenement is severed into several tenements. So, that right which is being enjoyed by the entire tenement, suppose what right normally? Passage right, cart track or water rights. Even after severance also, severed plots or lands or owners, they will continue to enjoy the same rights as it was available previously to the when it was in a common tenement. So, for example, there is ABCD land is having about 4 acres say ABCD land. So, out of that land, a owner of ABCD land is sold a rear part, means roadside part he retained owner, and suppose eastern side road, eastern side part he retained and western side portion he sold. That means a common tenement now it is severed by virtue of a sale. Now, when it is in common tenement, you used to exercise his passage right, cart track rights through his land to the eastern side road. Now, the rear owner, rear means he sold the land which is on the rear side, on the western side. So, that owner also continues to enjoy this passage rights across A's land, A's remaining land to the eastern side road. So, even it is not specifically mentioned in the document, but by term easement of necessity, the owner who purchased that land on western side, as of easement of necessity under this act, is entitled to enjoy the previous passage right available when it is in common tenement to reach the eastern side. That is known as easement of necessity. A severance of common tenement, tenement is nothing, land is a must here. Even after severance also the right continues to the owners who newly comes in place of original owner. So, severance of common tenement, common land is an important aspect here. Ikkada by way of illustration I will read only one. Owner of the land ABCD sells a small part of it OPQRS ikkada icharu ikkada to another person. ABCD is fenced land with only one gate G. In such a case, it would be proper that the purchaser should have the privilege of right of way from gate G to his plot of land OPQRS, because without such right of way, he would not be able to enjoy his land at all. Such a privilege is called an easement of necessity technically. That means, in order to enjoy his land effectively, a purchaser from the owner enjoys passage rights which were available previously when that land was in a common tenement. So, that is easement of necessity. So, he enjoys that right. So, that is one illustration. Similarly, ABCD land is there and that is say 2 acres, even 100 acres also it is same, I will come to that, 2 acres. So, there is a well in rear side, western side, and eastern side portion is there, and he sold some land. This time he sold eastern bit retaining Y, retaining rear bit. There is a well. So, before severance, this entire for water supply to the entire land is a source is well in their land. So, even after severance also, the newly purchased owner enjoys as an easement of necessity to irrigate his plot also from that well. So, that is easement of necessity for better enjoyment of the property that he has purchased. So this is most important also subject also, because so many questions are, why does an easement of necessity arise? When it is arise on severance of common plat, very easy. What are easements of necessity? ఏమేంటి? పాస్వేస్, water rights, etc. Write a short note on easement. So several questions are asked on this subject. So of course, depending upon the marks, they may ask 1 or 2 questions, but you can't help, you have to go through and understand the theories. Okay. Now next వచ్చి easements of quasi easements. What is quasi easements? Quasi easements are those easements that also arise out of severance, but there is no absolute necessity as far as quasi easements are concerned. The person who purchased the land can enjoy his land, but he cannot enjoy that comfortably without that easementary right. But there is no absolute necessity. So that is called quasi easement. That also arise out of severance of common tenement only. But the easement of necessity is absolute. There is absolute necessity. Here there is no absolute necessity. That is what easement of quasi easement that are called. So what are all the quasi easements? Easements of light and air are the most common types of quasi easements. The right to take water for purpose of irrigation is another example of quasi easements. A drain has also been held to be a quasi easement by Madras and Allahabad High Courts. So therefore, the other instances of easements are as easement of drainage and easement of channel, irrigation channel. Okay. Then next comes, what is the difference between easement of necessity and quasi easements? In order to claim a quasi easement, the easement must be shown to be both apparent and continuous. So we have already dealt with what is apparent easement and continuous easement, which conditions do not form the requisites of an easement of necessity. So easement of necessity, you need not to prove it is apparent and continuous. Further, the necessity involves in case of an easement of necessity is absolute necessity. That is one without which the property cannot be enjoyed in any way, much less in the way in which it was enjoyed formerly. In case of quasi easements, the necessity is not absolute but qualified. That is, it is one without which the property, though it may be enjoyable otherwise, cannot be enjoyed in the same way in which it was enjoyed formerly. Thus, if necessity is absolute, the right claimed would be an easement of necessity, and the case would fall under clause A are the examples. But if such a necessity is qualified, and further if the right claimed relates to an apparent and continuous easement, the case will fall under so and so illustrations. Lastly, in quasi easement, the parties involved can contract to the contrary, which they can't in the case of an easement of necessity. These are all the difference between easement of necessity and quasi easement. Then comes acquisition of easement by prescription. This is another important, section 15 to 7. Here I will read and then explain. Section 15 of the Act embodies the law relating to prescription. Even in the olden times, prescription was the commonest way of acquiring an easement. Thus, under Roman law, if the owner of a piece of land was absent from the country for 20 years and more, and another person had possession of such land during this period, on the lapse of this period of 20 years, the possession would mature into ownership and give a good title to the person in possession. That everybody knows. Thus, under the Roman law and later under the English law also, the doctrine of prescription was resorted to not only to establish easements, but in respect of other proprietary rights also. However, section 15 is concerned only with the acquisition of easement by prescription. Prescription connotes the effect of lapse of time in creating new rights and destroying old rights. A man who cannot show any other or better title may acquire property or certain rights by showing that he has been enjoying certain rights since very long time. The policy of law underlying the doctrine of prescription is to give legal recognition to the rights and title which have been enjoyed since a long time. This is what embodied in section 15. Section 15 of the Act lays down as follows: where the access and use of light or air to and for any building have been peacefully enjoyed herewith as an easement without interruption and for 20 years. This is most important, 20 years in Easement Act, because in the civil sometimes we read it as 12 years, but here in the Easement Act it is 20 years. Then it comes to how it is to be enjoyed. Your enjoyment should be strictly according to the law that is prescribed under section 15. So, your enjoyment should be peaceful without any legal obstruction, and it should be openly enjoyed and known, not secretly. Then as of right it should be enjoyed. So, how it explained here in this Easement Act, I will tell you, it is important. They say praise as of right is amply covered by the Roman expression nec vi, nec cum, nec precario. What are all these terms? It is most important as far as examination point of view. The expression means that the enjoyment of the easement should be without violence, that is nec vi, and peacefully అని చెప్పాం కదా. Without stealth, that is nec cum, and stealthily should not be enjoyed, and also it should be without permission, it should be without permission, nec precario, because if you nec precario is without. These triple characteristics may be summed up by saying that easement was enjoyed as of right. So, nec vi, nec cum, nec precario, these are all the terms that are used, Roman expressions. So, this may be this nothing, this denotes that peaceful enjoyment as of right without any interruption, and another thing, without permission. But if it is a permissive position, it cannot be a prescriptive right, it can never mature into a prescriptive right. That is what is in their Roman letters it is explained. Okay. This is about this one. Then next, then doctrine of last grant. An easement based on prescription is sometimes explained by creating a legal fiction of a last grant. The presumption involves it is that there was a grant of the right in the past, but that such a right has been lost. That is what I told you. If you enjoy something, some right for so many, more than 20-30 years, and you have no basis to prove that right or documentary evidence, whatever it is, law presumes that you are legally inducted or in that position of that, and you are legally enjoying it, but you have lost that grant which you have got. It presumes that somebody has granted a right and that is lost. That is the principle of last grant. So, that is sometimes used in deciding a prescriptive right also. Then there are certain rights which cannot be acquired by prescription. What are all those? For examination point, it is section 17. A right which would tend to the total destruction of the subject of the right or the property on which, if the accusation were made, liable would be imposed. A right which would tend to the total destruction of the subject of the right, that is you cannot get it, prescribed right. A right to the free passage of light or air to open space of ground. A right to surface water not flowing in a stream and not permanently collected in pool, tank or otherwise. A right to underground water not passing in a defined channel. So, these are all rights you cannot get, cannot be acquired by prescription. Then what is customary right? The next one, 18. An easement can also be acquired by virtue of a local custom. Such easements are called customary easements. An example, ఒక illustration చెప్తాను. By the custom of certain village, every cultivator of village land is entitled as such to graze his cattle on the common pasture. So, pasture rights. A having become the tenant of a plot of uncultivated land in the village, breaks up and cultivates that plot. He thereby acquires an easement to graze his cattle in accordance with the custom. సో ప్యాచ్యూర్ ల్యాండ్స్ విలేజ్లో పశువులు మేస్తానికి కొంత ల్యాండ్ వదిలేసేవారు. దాన్ని ఏంటంటే ప్యాచ్యూర్ ల్యాండ్ అంటారు కామన్గా. అది బై కస్టమ్ ఎవ్రీబడి ఆల్ ది ఓనర్స్ క్యాటిల్ కెన్ గో అండ్ దే కెన్ బి ఫెడ్ దేర్. By custom of certain town, no owner or occupier of house can open a new window, that is a privacy rights, because your side by owner cannot open a window which prevents the which violates privacy rights of your members in your house. Suppose in a common parlance day to day work, the ladies sometimes they may not be dressed casually, they will be dressed while working. So somebody opens a window just which is directly visible into your house and your in a kitchen. So that those days they are not allowed. That is they are affecting the privacy rights of other owners. Of course, they are, sometimes these days courts also are not granting any, because the apartment culture and population increased, and now you can't dictate terms with the neighbor saying that you don't open window this side. So but previously this right is there. Even our time also have done some cases on privacy rights, and some courts granted, some courts not granted, but the privacy right is recognized in Easements Act. What are the important customary easements recognized by law? What are all easements of patronage? Already I told. Easements of religious observations, easements of privacy, just now, easements of sports and recreation. That is what about the most important customary easements. Then there is a, what is customary easements and prescriptive easements? There is some difference. In case of customary easements, it does not depend on proof of peaceful enjoyment for 20 years. But peaceful enjoyment for 20 years is a necessary condition for prescriptive right. Customary easement has its origin in custom, but whereas prescription it has its origin in prescriptive right. It can be enjoyed only in a particular locality, custom. It is not limited to any locality easement. Anywhere, everywhere the easement right is available. It belongs to a class or locality, but it is a personal right. But where it is peculiar to certain class of persons, community of persons in particular area and in that locality, it must be reasonable. It need not to be reasonable. Whereas prescriptive easement, this is all little differences. Then coming to disturbance of easements. So extinction of easements by dissolution of the right of the servant owner, then by release by the dominant owner to the servant owner, either express అంటే డామినెంట్ ఓనర్ నాకు ఇది అక్కర్లేదని ఇంప్లాయిడ్గా కానీ ఎక్స్ప్రెస్లీ కానీ నాకు వద్దని అంటే. దెన్ by revocation by the servant owner in exercise of power reserved by him in his behalf. Suppose this servant owner reserved his right that he will provide a passage right or some other right to the dominant owner for particular period. That period is over, he can revoke it. Then by expiry of limited period, and then by termination of necessity, by becoming useless, that is incapable of being at any time and under any circumstance beneficial to the dominant owner. By permanent change in the dominant heritage, by the servant heritage being so materially altered by some superior force that the dominant heritage can no longer enjoy. Then by complete restriction of either of the heritages. By unity of ownership, this is another important. What is the unity of ownership? In the sense, suppose A and B plots are there, common owner. So he sold B plot to somebody else. So he can enjoy all the rights through A plot, which that land is subjected when it is a common tenement or common land. But thereupon that B land again being that again the A purchases the B land, his own land, he purchases from that gentleman after some time. Then the unity of ownership. So now for both the plots, owner is A. So kabatti unity of ownership, because I said the right you enjoy on your own land is not an easement. So when it becomes entire plot, it becomes your land, there is no question of easement. That is what extinction of easements is the condition. By total not enjoyment for unbroken period of 20 years, that you will lose. So, these are all. Then comes to licenses. License. What is a license? When one person grants to another or to definite number of other person a right to do or continue to do or in or open upon the immovable property of the grantor something which would in the absence of such a right be lawful, and such a right does not amount to an easement or interest in the property, the right is called license. Section 52. Here you must understand the difference between license, incidentally lease. In case of lease, a right is created in the property. In case of license, no right is created. You are only given permission to use that land. Suppose I will tell you an example. There is one land, one site by the side of some school. So, A is the owner of that site. So, a school management sought permission, license of A, who is the owner of adjacent plat or ground, to use it for a particular purpose as a playground of the children. So, suppose he permits. So, that is called license, because he has not given on lease, it is only permission he has given. So, that is called license. Here one thing, a licensee rights are very limited. Suppose in the bargain the school management without the permission of licensor who gave owner of that plat, they made some construction. So, when a owner invoked, they revoked his license, they started claiming that we have constructed something pakka there with slabbed building, we need, we are entitled for the compensation or rate of that, by whatever it means. But they are not entitled to ask when they are taking the land on license, because we must understand that license has no right in that land, licensee, because damnum in a torts there are two maxims are there, damnum sine injuria, injuria sine damnum. See, damnum sine injuria is that violation, damnum sine injuria is violation, some violation without violating the, some damage caused without violating the legal right. So, here suppose the owner of the land without paying compensation for his convenience, he is removed that constructions. This gentleman came to court, abbe నేను construct చేశాను అయ్యి పక్క constructions, but without giving compensation he has taken over the site అని కోర్టుకు వస్తారు. ఇక్కడ what is his right? A owner has violated no legal right with licensee, because that is why this maxim comes into play, damage, damnum sine injuria, damage without the violation of legal right. Once your legal right is not violated and you on your own accord without the consent of owner you made some constructions, you are not entitled for damage. That is what the rulings of the courts. So, incidentally, what is injuria sine damnum? Injuria sine damnum is that, no damage caused, but your legal right is violated. Suppose you are not permitted to vote for certain candidate, even then that candidate won the election, but because no damage is caused because non-voting of yourself, but you came to court, but court said maybe that candidate won or he was defeated, it does not matter, but his legal right to vote is violated, but he is entitled for compensation. So, that is the difference between damnum sine injuria, injuria sine damnum. Licenses comes under damnum sine injuria. This is for explanation's sake, how to understand the subject, right? Okay. Then, here we have to think license in the context of Easementary Act. So, it is better I will tell distinguishing between license and easement, then you will understand. It is a right in personam, that is, it binds only the parties concerned, but easement is a right in rem, it is available against any person whose hands the property passes. Then license, it is a right to do something only, but it is a right to do something or to prevent something being done in case of easement. In case of license, it is not appurtenant to land. It is easement is appurtenant to land. It is most important difference. License, it is normally not transferable. Easement is transferable. Dominant heritage is sold, right also will get transferred. దస్తవేజులో రాస్తాం కదా, దీనికి సంబంధించిన యావత్తు ఈజ్మెంటరీ రైట్స్తో సహా అని రాస్తాం కదా. రైట్ ఆఫ్ ఎగ్రెస్ వాట్ ఎవర్ ఇట్ ఈస్, రైట్ ఆఫ్ కాట్వే, రైట్ టు టేక్ వాటర్, వాట్ ఎవర్ ఇట్ ఈస్, which ever is available in case of agricultural lands, right of passage and irrigation rights. In case of plat, house site, rights of passage or rights of support, that is whatever it is. The next difference is license. In case of license, the transferee of land over which the license is available is not bound by it. The transferee of that land. The transfer of the servant land is bound by the easement. అంటే ఇప్పుడు సర్వెంట్ ల్యాండ్లో డామినెంట్ టెన్మెంట్ ఎంజాయ్ చేస్తానికి రైట్ ఉంది. సో సర్వెంట్ టెన్మెంట్ ఇఫ్ ఇట్ ఈస్ సోల్డ్ టు సమ్ బీ ఈజ్ బౌండ్ బై దట్ ప్యాసేజ్ రైట్స్ విచ్ ఆర్ అవైలబుల్ టు ది డామినెంట్ ఓనర్ అండ్ డామినెంట్ టెన్మెంట్. ఇక్కడ సమ్ లిటిగేషన్ వద్దు, కొత్తగా ఓనర్స్ వచ్చి మీకు మా బోధి మేము మూసేస్తాం, కార్ట్ ట్రాక్ మూసేస్తాం అని అంటాక లేదండి. ఎందుకంటే ఈజ్మెంట్, దట్ ఈస్ ది బ్యూటీ ఆఫ్ ఈజ్మెంటరీ రైట్. Going from others land only is easementary right. You can't simply say that I will close, because if you see if you compare in a context of agricultural lands, there are jamindars olden days 100 acres is one common tenement. Now that 100 acres lowest owner comes to road across all the 100 acres. Nowadays, the Zamindari system is not there, and that 100 acres is severed into 100 owners, 100 sales, or whatever, 100 partitions or 100 gifts. So, there are 100 owners. So, lowest owner is entitled to come to the road across all these 99 acres. That is the beauty of easementary right. Nobody can say you have no right across my land. So, provided when it is a common tenement, that is having those rights. That is the beauty of easement of necessity. So, that you have to realize in that way for understanding, compare the agricultural lands. That even irrigation rights also same. See, government irrigation channels will be there to some extent. From government channels, 100 acres it has to go down to the last owner. So, the channels has to go across the owners of so many people. So, upper owner cannot simply close that irrigation channel, because there, as an easement of necessity, the lower owners are being has to enjoy. So, that is the beauty of easement rights. Now, the license and easement. Transfer, about transfer that I have given this explanation. It is revocable at the will of the grantor. Except in two cases that is given, it is not revocable at the will of grantor. So, license can be even orally I am invoking, there is enough. I am revoking, sorry, that is enough. So, but in the case of easementary right, that is not possible. The licensee cannot sue a stranger in his own name if the license is interfered with. Licensee, suppose a licensed land somebody disturbs, he can't, owner has to file a suit, because license have got no right permission in that land. The holder of the right of easement can sue in his own name if the easement is interfered with, that you all know. It arises only by grant license. It can be acquired in a number of ways, easement. Then license continuous use is not necessary. Continuous use is necessary in case of easement. It may be granted by co-owner if the same does not amount to unreasonable use of joint property. It can be granted by a co-owner without the consent of the other co-owners. So, this is the difference, basic difference between license and easement. Now, incidentally, a lease and license also I am telling. In case of lease, transfer of interest already told. In this, there is no such transfer license. Accretions are deemed to be comprised in the lease. Licensee acquires no interest in accretions. A lease is transferable and heritable. License is neither transferable or heritable. A lease can be terminated by forfeiture. There is no such termination in license. A lease can be terminated in one of the 8 ways prescribed under section 111 of TP Act. A license is revocable at the pleasure except in 2 cases. A lessee's interest is not defeated by subsequent transfer of property. A subsequent transfer of property terminates the license. A lessee can sue trespassers and strangers. A license cannot sue. Owner has to sue. Death of either party does not affect a lease. A license is terminated by death of either party. A lessee can be ejected if he denies the title of the lessor. A licensee cannot be ejected in such circumstances. A lease can be assigned to a third party. A license cannot be assigned. A lease need registration. A license need not to be registered. So, these are all the differences between lease and license and easement. This is also one of the important question for multiple choice, because wherever there is some importance, I am insisting on those points, because the historical background, all these things as it is taught in law college, we can't teach in that way when we are preparing for examination purpose, because it is better, because what is important we are insisting on that points, but how other than this important other aspects also you have to go through, because as far as the judicial exams are concerned, they are very easy. Only thing you have to put up a hard work, because it is not random, they can't ask any question they want, examiner. Suppose if you want to ask a question in out of Easementary Act, he has to ask from Easementary Act only, he can't go out. So, that you keep it in mind. It's a very easy exam, only thing the hard work is required. That is what the disturbance of easements and how to file suits and all, they are all there. So, here at the end of the day, I want to insist upon the one thing I would like to tell. See, the positive attitude is very important to the younger advocates who is appearing for exam. So, you talk to yourself and say to yourself always that you can win, I can win, I can win, I can win. That should be in your mind, because winners do not do different things, they do things differently. Keep this in mind. Winners do not do different things, they do things differently. So, how they do things differently? So, the persons do things differently only will get success. So, that differently is hard work and increasing your knowledge with positive attitude. So, these things you must have early morning. If you see all this exam date, I request you to wake up in the early morning by, if you can wake up 3 or if not 4. So, 2 hours you read. Easement Act is very small act. You read. Now with the help of this video also, while you are reading, you listen this video and keep reading. So, it will enhance, it will enhance your efforts, decrease your time, and it will enhance your knowledge. So, that is how you should go. I can win, I can. That is what you have to say to yourself after getting up in the early morning. So, the person getting up in early morning is always advantage there to him in the life itself, not only examination, in the life itself, because by that time 8, 9 o'clock somebody gets up, this man who gets up at 4 o'clock, all his main job is over, because he is reading and preparing for examination, almost half the job is over within 2-3 hours. So, that you keep it in mind, and all the best, because nowadays these posts are very, very important, because salaries are more, facilities are more, and you will be more respected than anybody else on the earth. Even in the India, people still they believe that courts are temples and judges are God. So, that is the sentiment people are having. So, you have a positive attitude and go through for your examinations, and I hope that these videos also help in enhancing your knowledge. Thank you very much. Again, next I will come with the specific relief act or contract act. whatever it may be. You go through the videos, it will be some helpful, it will be of some helpful to you. Okay, thank you very much. We will meet in the next video.
మీ ఏలూరు చందన బ్రదర్స్ షాపింగ్ మాల్లో ఏప్రిల్ 15వ తేదీ నుండి సూక్ష్మ లోపాల వస్త్రాల మేళా. కంటికి కనిపించని సూక్ష్మ లోపాలు గల వస్త్రాలపై అప్ టు 61% అత్యంత భారీ తగ్గింపు. పట్టు చీరలు, ఫ్యాన్సీ చీరలు, వర్క్ చీరలు, కాటన్ సారీస్, హ్యాండ్లూమ్ సారీస్, లంగావోణి సెట్స్, డ్రెస్ మెటీరియల్స్, చుడిదార్స్, టాప్స్, మెన్స్ వేర్, కిడ్స్ వేర్, బెడ్షీట్స్, షూస్, చెప్పల్స్, 1 గ్రామ్, బెంటెక్స్, గిఫ్ట్ ఆర్టికల్స్, హ్యాండ్ బ్యాగ్స్, ట్రావెల్ బ్యాగ్స్, హ్యాండ్లూమ్ ఫర్నిషింగ్స్ పై అత్యంత భారీ తగ్గింపు. తానుల్లో మిగిలిన జాకెట్ ముక్కలు, సూటింగ్ ముక్కలు, షర్టింగ్ ముక్కలు అత్యంత తక్కువ ధరలకే లభించును. ఈ ఆఫర్ ప్రత్యేక కౌంటర్స్ లో స్టాక్ ఉన్నంత వరకు మాత్రమే. విచ్చేయండి చందన బ్రదర్స్ షాపింగ్ మాల్, మెయిన్ బజార్, ఏలూరు.